Okay, so we're here at 26 CFR 301-7701-7, trust, domestic and foreign. Okay, and the first thing it says is a trust is a United States person if a court within the United States is able to exercise primary supervision over the administration of the trust, and one or more United States persons has the authority to control all substantial decisions of the trust. So they're telling you right there that if you have a trust granted from the United States or granted from one of the agencies, that the courts have the authority to control all the decisions regarding that trust. And this is why when you go to court, people will say that the judge is actually a trustee, which he is, but they charge you as a trustee. They put the onus on you and charge you with malfeasance or mismanagement of the trust. And since you don't have an express trust, remember that word, that says you are not the trustee, they can presume that and proceed accordingly. So we're going to read a few more things here. So they say that they can have the authority to control all substantial decisions of the trust, that they're able to exercise primary supervision. So let's see what primary supervision is. All right, primary supervision. The term primary supervision means that a court has or would have the authority to determine substantially all issues regarding the administration of the entire trust. Okay? A court may have primary supervision under this paragraph, notwithstanding the fact that another court has jurisdiction over a trustee, a beneficiary, or trust property. So, when they say they have substantially supervision over all issues regarding the administration of the entire trust, that means they control everything about that case, which is a trust, being in court, being administered by the judge and the either state attorneys, who are trustees as well, the prosecutor, what have you. Now, we're going to go into one more thing, and it is here. Okay. A trust is a United States person for purposes of the Internal Revenue Code on any day that the trust meets both the court test and the control test. For purposes of the regulations in this chapter, the term domestic trust means a trust that is a United States person. Okay? That's the trust that is not foreign. That is the trust that the United States grants or that the United States governs. Now they make that very clear, not necessarily here, but throughout this whole code and throughout other laws that we've read so far. All right? However, when they come to foreign trust, they say the term foreign trust means any trust other than a domestic trust, and they leave it at that. So that lets you know that they don't want you messing around with foreign trust because they don't give you any information about what that's all about. So we already read about the primary supervision. Now, we also already read how they explain or how they briefly just touch on what a foreign trust is. So it should be clear that a private and foreign trust are two different entities and that they're recognized. It's just that the foreign trust is not explained by any of the code or any of the statutory references because they don't control a foreign trust. And that's something that you should note. Okay? So we're just going to go through a summary of what we've already gone through because we're coming to the end of this module. And that is that a trust is a contract that you and another have helped to agree I'm sorry, that you and another have agreed to help a third party. Okay, that is very basic. The two classes are revocable, which is the grantor can control it. He can change it, and he can even collapse the trust on his own. That means terminate it. And the other class is irrevocable. The grantor cannot control, amend, or collapse the trust. The trustees have to have a hand in doing that. Okay? The law of the trust is its indentures. All right? They guide the conduct of the trustee. Let him know what's to be done in all instances and all circumstances. And the more intricate and precise you are, the more detailed, the better informed your trustee will be. All right? The trust is a legal person able to act and hold property near the utility of a living being. Again, as I said before, I think we'll see later on in this course that natural person can be used to refer to a common law trust versus a corporate or statutory trust considered an artificial person. And that's the delineation that I want you to see. I don't think a domestic trust is considered a natural person. As a matter of fact, they are not. But a private trust is considered a natural person. And of course, they're not going to have that in the code, but we'll see it later on. The top most common purposes for a trust are succeeding wealth and reducing liability, such as taxation, public exposure, etc. Okay, you can name your trust any name you want, except not any name that indicates that it is something other than a trust or other than representative of you. So you can name it your name, of course, and administer it from that perspective. The all capital letters name is a domestic trust indicated on the driver's license, the social security card, etc. And any domestic trust is answerable to the United States scrutiny. They're answerable to the judiciary, the courts, and they're answerable to the IRS. Okay, without question. Now you may question it, but they run right over you because they know that by the law that they're able to take control and administrate that trust any way they see fit. And since commerce is all about money, they're going to administrate it 95% of the times so that they get paid. All right, point blank. Now, some important points that I didn't cover or I didn't show any reference to, but that you should know. All right, and we talk about a testamentary trust, which is created by a will, which begins its existence upon the death of a person making the will. So a testamentary trust can only exist when the person makes the trust, who the grantor of the trust passes away. Then it automatically becomes a testamentary trust. All right. And they are irrevocable by definition because, of course, if the grantor has passed, is no longer here, then the grantor cannot change anything, and no one else is authorized to change anything. So a testamentary trust is, by default, any trust that exists once the grantor has passed, and it also is, by default, an irrevocable trust once the grantor has passed. Now, a living person creates an inter vivos trust during their lifetime, and it can be established as revocable or irrevocable. An inter vivos trust can be a simple, complex, or grantor trust, depending on the trust instrument. So those are some things that I want to cover really quick. Inter vivos, that just means a living trust if the person's still alive. Testamentary trust means that the person created the trust and has passed. All right? And that concludes this module. We will proceed to the next module, Module 2.